This is the Manhattan District Attorney Alvin Bragg. On March 30th, 2023, Bragg's office indicted former President Donald Trump on 34 counts of falsifying business records in the first degree. On April 4th, Trump was arraigned in Manhattan criminal court and pleaded not guilty. In a statement of facts, Alvin Bragg writes, "The defendant, Donald J. Trump, repeatedly and fraudulently falsified New York business records to conceal criminal conduct that hid damaging information from the voting public during the 2016 presidential election." Each of the indictment's 34 counts relate to a single hush money payment of $130,000 to actress and director Stormy Daniels. Here is a breakdown of the 34 counts. 11 counts are related to invoices submitted to Trump by his former lawyer, Michael Cohen. 11 counts are related to checks written by Trump or using his funds to reimburse Michael Cohen. 12 counts are related to accounting records made for the reimbursements in Trump's books. And each of the 34 counts contain the same exact language. The grand jury of the County of New York, by this indictment, accuses the defendant of the crime of falsifying business records in the first degree in violation of Penal Law 175.10, committed as follows. The defendant, in the County of New York and elsewhere, on or about, insert date here, with the intent to defraud and intent to commit an other crime and aid and conceal the commission thereof, made and caused a false entry in the business records of an enterprise. The first 4 counts occurred on February 14th, 2017. An invoice submitted to Trump by Michael Cohen, an entry into the Detail General Ledger, another entry in the Detail General Ledger, and a check written to Michael Cohen. Wait, the DA is saying that Trump committed 4 crimes in one day, including accepting an invoice and then paying it? Oh man, they got Trump now.
Under New York state law, it is a felony to falsify business records with intent to defraud and an intent to conceal another crime. That is exactly what this case is about. 34 false statements made to cover up other crimes. These are felony crimes in New York State, no matter who you are. We cannot and will not normalize serious criminal conduct.
We cannot and will not normalize serious criminal conduct. And if you know anything about Alvin Bragg, that is just pure comedy. During Alvin Bragg's first year in office, 52% of felony cases were downgraded to a misdemeanor, and his office declined to prosecute over 1,100 felony cases. But sure, he's really serious when it comes to criminal conduct. Anyway, Bragg said that these 34 false statements were made to cover up other crimes. But if you read the indictment, there is no other crime listed. Now you might be thinking, was the payment to Stormy Daniels criminal conduct? No, because hush money payouts are not illegal. It is not a crime to pay people for their silence. So the question is, what is the other crime?
I'm wondering if you can specify what laws were also broken.
Right. So let me say as an initial matter that the indictment doesn't specify that because the law does not so require.
In other words, Alvin Bragg is violating the 6th Amendment of the Constitution by not disclosing to the defendant what crimes were committed or what laws were broken. And he doesn't have to tell you either because it's a secret.
So I mentioned a couple of laws, which I will highlight again now. The first is New York State election law, which makes it a crime to conspire to promote a candidacy by unlawful means.
Bragg brought along with him charts explaining the case, with a line stating that there was an intent to commit or conceal another crime, including state and federal election laws. But there are 3 problems with that statement. 1, Donald Trump was running for president in a federal election, which means that state election laws do not apply here. 2, if Trump did violate a federal election law, Bragg does not have the jurisdiction to indict someone for a federal crime. And 3, there is no mention of election law crimes, state or federal, in the indictment. It only lists 34 counts of falsifying business records. And if you're going to indict a former president who is the current frontrunner for the Republican presidential nomination, your case needs to be not only detailed and precise, but it also needs to be airtight. And Bragg's case is none of those things.
I further indicated a number of unlawful means, including more additional false statements, including statements that were planned to be made to tax authorities.
Statements that were planned? I'm sorry, what?
I also noted the federal election law cap on contribution limits.
Again, Bragg is mentioning federal election law when he has no jurisdiction to indict someone for federal crimes. And if he thinks he does, well, he's not going to bother to explain it.
But why weren't there those crimes charged? Why wasn't he charged with those crimes?
Well, I'm not going to go into our deliberative process on what was brought. The charges that were brought were the ones that were brought. The evidence in the law is the basis for those decisions.
The charges that were brought were the ones that were brought. Right. Well, one thing is for sure, Alvin Bragg is the Karine Jean-Pierre of district attorneys. Another problem with Alvin Bragg's case is that he alleges that by falsifying business records, that Trump defrauded voters into electing him. I will read the top of the indictment again. The defendant, Donald Trump, repeatedly and fraudulently falsified New York business records to conceal criminal conduct that hid damaging information from the voting public during the 2016 presidential election. But the first of these so-called crimes occurred on February 14th, 2017, which is more than 3 months after the 2016 election. And the indictment shows that all 34 counts occurred throughout 2017. And according to the indictment, the last crime occurred on or about December 5th. So how would falsifying a business record in 2017 affect an election that happened in November 2016? Oh, right, it wouldn't. Furthermore, how was the voting public deceived by internal business records that they did not see nor were even aware of? Oh, right, they weren't. Another problem is that in New York State, there is a 5-year statute of limitations on most felonies, and that includes charging someone over falsifying business records. Again, the last alleged crime occurred on December 5th, 2017, and Bragg's indictment was filed March 30th, 2023. And if you do the math, that's 5 years, 3 months, and 25 days between dates, which means that the crime is no longer subject to prosecution, and therefore it's too late to bring felony charges, right? Right? Well, it's not that simple. Bragg's office will likely argue that they are well within the statute of limitations, and they have 2 different avenues to take. The first is that under New York state law, the statute of limitations is told or paused when a defendant is continuously outside of the state. And obviously, while president, Trump spent the majority of his time in office not in New York City, that's for sure. However, tolling most commonly occurs when the defendant becomes a fugitive from the jurisdiction where they committed the crime. So it's unclear if tolling could be applied in this case. Then there were the executive orders signed by then Governor Andrew Cuomo that paused all statutes of limitations in New York because of the pandemic. The pausing didn't end until January 2nd, 2021. So Bragg could argue that because of the pause, the alleged crime occurred within the statute of limitations. But if that is the case, then that would mean alleged felonies that occurred before September 2017 would not be subject, which would eliminate 22 of the 34 counts in the indictment. So under the Cuomo EOs, it's unclear whether the statute of limitations could or should be eligible in the Trump case, considering that the grand jury wasn't even impaneled until 2 years after the pausing ended. So here's what happens next. Bragg's office will soon turn over all of the evidence it obtained in their investigation to Trump and his defense team. Trump's team will then have until August 8th to file defense motions, which will most likely include a motion to dismiss the case. However, the judge in the case isn't scheduled to make rulings on any motions until December 4th. And if he doesn't outright dismiss the case before then, you're going to see Trump lawyers pull out all the stops to delay. And that means if the prosecution is lucky, they might get a trial date sometime in 2025. Anyway, that's it for now. Follow me on Twitter at Don'tWalkRun. And as always, thanks for tuning in. Be sure that you're still subscribed to the channel, and I hope to see you next time. If there is next time.